Alright, Part 370. Principal practices for the investigation, voluntary disposition, and loss of damage claim for the processing salvage. 371. Applicability regulations. 373. Filing claim. 375. Acknowledgement of the claims. 377. Investigation claim. 379. Disposition claim. 370. The processing salvage. Alright, 371. Applicability of the regulation. Regulations set forth and partial govern the process of the claim with the loss of damage, injury, delay with the property transport, except with the transportation interstate with the foreign commerce by each motor carrier, water carrier, the freight forwarder, here and after called their carrier, subject to the Title 49 U.S. Standard Code, Subtitle 4 with a Part B. 373 with the filing of the claim, compliance with the regulation claim with the loss of the damage bag, with the loss of the damage, injury, delay with the cargo shall not voluntarily pay with the carrier unless filed as provided with the paragraph B with the section with the receipt of the delivering carrier with the carrier issue with the billing of landing receipt, the ticket of the baggage, check of the carrier with the whose line with the alleged loss of the damage, injury, delay occurred within the specified time limits applicable there and to it as otherwise may be required by the law, in terms of the bill of landing, other contractual carriage, all tariffs, provisions applicable thereto, the minimum filing requirements, written electronic communication agreed with the review by the carrier, the shipper, the receiver, the involved firm, and the claimant filed with the proper carrier within the time limit specified with the bill of landing contract for the carriage transportation and containing the facts sufficient identified with the baggage and shipment of the shipment of property, asserting liability with alleged loss of the damage, injury, and delay with the making of the claim of the payment of the specified determined amount of the money should be considered sufficient compliance with the provision filing claim with embrace for the bill of the landing and other contract with carriage provided. However, their claims are electronically handled procedures are established to ensure reasonable carrier its access to supporting documentation, documents not constituting claims, bad order reports, appraisal reports, damaging notation for the shortage of the damage of the both of the freight bill of the delivery, receipt of the other documents, inspection reports issued with the carrier with either inspection agencies, whether the extent of the loss of the damage indicated with the dollars and cents otherwise shall be standing alone but not considered of the carrier sufficient to comply with the minimum claim filing requirements specified in paragraph B of this section. Claims D. Claims filed with an uncertain amount. Whenever the claimant is presented against the motive proper carrier with the uncertainty amount as such as $100 or more of the carrier against such for the claim of the file to determine the condition of the baggage shipment involved, the time of the delivery and what was delivered, and shall certainly nearly as possible to the extent if any of the law of the damage which is responsible shall not, however, voluntarily pay a claim or in such circumstances unless in the formal claim in writing and is specified to determine what amount of the money shall have filed within accordance with the provision in paragraph B of this section. Other claims. If the investigation claim develops one or more of the other carriers have presumed with a similar claim of the same shipments with the carrier investigation such claim that they shall communicate with each of the other carriers prior to ending any agreement entered in between and among them proper disposition claim. Such claims shall notify of the claimant of recipient confliction overlapping claims shall require further substantiation for the part of each of the claimant his or her title with the property involved with his or her right with respect to such claim. Alright, 375, acknowledgement of claims. Each carrier shall, upon receipt, written electronic transmission, proper claim of the manner of the described of the regulation, pass acknowledgement of the receipt of the such claim, written electronically of the claim within 30 days after the date of the recipient of the carrier, unless the carrier has paid with the decline with the such claim written electronically within 30 days of the receipt. Thereof, the carrier shall indicate with the acknowledgement of the claimant with additional documentary evidence of the pertinent information may be required further to process the claim with a preliminary examination of the claimant is filed with the may be revealed, but the carrier shall have at the time of each of the claim with the receipt of the creative of the separate file with a certain sign thereto the successful claim filed number, the note, the number of all the documents filed within support of the claim and all records corresponding with respect to the claim, including the acknowledgement of the receipt at the time of such claim is received with the carrier with the shall cover the date of the receipt with the re-record with the face of the claim with the document with the date of the receipt shall appear with the carrier's acknowledgement with the receipt of the claimant. The claim shall also become the claim file number, the note of the shipping of the other possession with the delivery receipt. If any of the covering shipment, unless the carrier shall establish the orderly, consistent internal procedure assuring all the information contained in the shipping order delivery receipt is tallied with the sheet with the other pertinent reports with respect with the transportation shipment of the claim of the base is made available with examination upon receipt of the claim. That shall all such records and documents of the true and complete reproduction thereof. In fact, examined of the course investigation with the claim and the appropriate record of the made with the such examination has in fact taken place. That such procedures prevent the duplicate otherwise unlawful payment of the claims. 377. 377. The investigation claims. Promptly investigation required. Each claim is filed against for the carrier in the manner prescribed by this part shall be promptly thoroughly investigated. If the investigation has not already have been made prior to the receipt of the claim, the supporting documents is necessary part of the investigation. If the claim is supported with the original bill of landing evidence of the freight charges, if any, in the either original invoice, photograph the copy of the original invoice, exact copy thereof, the extract made thereof the certified claimant to true correct with respect to the property value involved with the claim and the certification process, prices, value of the trade, of the other discounts, allowances, deductions of any nature whatsoever, the terms thereof, the depreciation reflected thereof, the provided, however, the property involved with the claim has not been invoiced with the consignor, with shown with the bill, with the landing, with the invoice does not show the price of the value where the property involved has been sold, where the property has been transferred. Bookkeeping values only the carrier shall be voluntary paying and paying a reclaim and require the claimant to establish the destination value and the quantity shipped and transport involved to provide further the supporting documents to determine the necessary parts of the investigation when the supporting documents are retained by the carrier. Possible Federal Motor Carrier Safety Administration inspection. Verification of losses. When the asserted claims a loss, entire package of the entire shipment cannot be otherwise authenticated with the time of the investigation, the carrier shall be taken with the consignor of the shipment involved with a certified statement of the writing of the property of which the claim is filed but is not received from any of its sources. Alright, 379, Disposition of Claims. Each carrier is subject to Title 49 U.S. Standard Code Subtitle 4, Part B, will receive the written electronically transmitted claim of loss, damage, baggage, loss, damage, injury, delay with the property transported, paid at the decline of the mark, make a firm compromise settlement with the writing electronically to the claimant within 120 days after the receipt of the claim of the carrier, provided that, however, the claim cannot be processed disposed within 120 days of the receipt thereof. The carrier shall, at the time of the expiration, each succeeding 60-day period with the claimant remains pending, and advise the claimant in writing electronically in the status of the claim, of the reason of delay making with the final disposition thereof, then shall retain a copy of such value if the claimant is in claim thereof filed thereon. When settling a claim for the loss of the damage of the household goods motor carrier, the defined 375-103 with the subchapter E for the replacement cost of the loss of the damaged items as base with applied with the depreciation factor arrive at the current actual value of the lost damaged item. Alright, 370.11, the process of salvage. When a baggage of material with the other party of the other property of the transported by the carrier of the subject to the provision of this part damage alleged to be damaged in consequences thereof the not delivered, it is rejected the review of the tenor thereof to do with the owner, consignment of the person entitled to receive such property the carrier after giving due notice whenever the practical to do so, but the owner and the other parties may have the interest of therein, unless advised the contrary after giving such notice shall undertake to sell and dispose of any of the such property directly by employment of the competent salvage agent. The carrier shall only dispose of the property any of the manner will fairly equally protect the best interest of all of the person having the interest therein. The carrier shall make the itemized record of the decision and identify the property involved with such to be able to correlate to the shipment of the transportation involved in the claim. If any of their filed thereon, the carrier also assigns each lot of such property successful lot number to note with lot number on the record. Its record, shipment and claim if any of the claim is filed thereon. Whenever the disposition of salvage material goods shall be made with the directly to the agent employed with the carrier thereon, salvage agent with the company with the carrier with one or more of the directors, officers, of the manager, the interest of the financial, otherwise carrier salvage record should reflect the particular each such transaction relationship, both in such cases may be. Upon receipt of the claim of the shipment of the salvage has been processed in the manner prescribed in the section, carriers shall be recorded in its claim thereon and a lot number assigned with the amount of the money recovered, if any, of the disposition of such property day of the transmission, middle such money to any of the person personally lawful entitled to receive the same. And that was part 370. And then we'll read 371, brokers for property. 370, principles, practices for investigation, voluntary disposition, loss and damage, and claims of processing and salvage.